Hey everybody, it's Chad. I hope you're having a great week. So this is my second video for Mississippi Cannabis News Network. Last week we talked about the First Amendment, and so this week we're going to talk about the Second Amendment. So I wanted to read it to you first, and then we'll talk about it. And so it's real short, it's just one sentence. So it says, a well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. So let's talk about it historically. So at the time that the Second Amendment was being drafted and written and put in place, so we had two groups in the U.S. So we had the Federalists and we had the Anti-Federalists. So the Federalists believed in a strong federal government, obviously. So the Anti-Federalists believed in the opposite. They wanted a strong state government. So the Federalists wanted there to be a strong national military, and the Anti-Federalists said, no, we'll have strong state militias. And then in the instance that we have a foreign attack, these state militias can be called up to defend the country, and that's how we'll do it. And so when you put it in historical context, that makes sense. We had just come out of the Revolutionary War. We had just fought the British. So that's why we had these two different sort of viewpoints on what we needed. So they were, Anti-Federalists were skeptical of a national military because they're like, we don't want to get in the same boat that we were just in with the British and the British troops and that military. Let's have our free states and we'll have our state militias, and that's how we'll roll. So obviously, our Constitution already provides for a national military. So the Second Amendment sort of became a compromise. It said, okay, we are going to have a national military. We will allow these state militias to be regulated and there to protect a free state, and that'll give you guys the right to bear arms. So that's what the Second Amendment was for. And so this was never an individual gun ownership. So that's because up until 2008, the Supreme Court had interpreted the Second Amendment based on the whole thing. So looking at the whole sentence, which talks about the state militia. However, in 2008, that's when we get the Heller decision. And so what the Heller decision did was extend that to individual gun ownership. So Justice Scalia for the court took that and sort of broke it out into two parts and said, okay, no, this also includes an individual's right to own a gun. However, he goes on to say that obviously has limits. It's not an absolute right that can't be regulated with limits. And in fact, what he says, and I have it right here because I don't want to misquote him. No, that's not it. Just kidding, here it is. All right, it says, like most rights, the Second Amendment right is not unlimited. It is not a right to keep and carry any weapon whatsoever, in any manner whatsoever, and for whatever purpose. So that's the Heller case, 2008. If you get a chance, read it. It's really long. It's like 157 pages. I get it. That's a lot to read. But it does sort of give this great historical context and then brings you all the way up from that. So obviously we can regulate an individual's right to gun ownership. So even before the 2008 decision, we had in the 80s the Brady Bill. That was Press Secretary Brady, who was shot when there was an assassination attempt on Ronald Reagan. And I think it was 10 years later in 1993 that President Clinton signed that. And so that was for background checks for individuals wanting to own a gun. We obviously have the assault weapon ban that was put in place. We know that government buildings, schools, private businesses can limit firearms on their property. And I know that each state has sort of, their own concealed carry. You have an enhanced concealed carry. You have all that. I'm not getting into all that because at the end of the day, what I'm talking about is that is a right that's not absolute, that can be regulated, that can have limitations. And so that's sort of like the big picture that I'm trying to show. A lot of times people say, oh, well, America is amazing because we have freedom. And so I'm always like, well, what does that mean? You know, what is freedom to you? And people like to talk about the First Amendment and the Second Amendment. And, you know, obviously none of these are so absolute that they're not still up for debate. I mean, there are lawsuits and interpretations of that are still ongoing to today. We didn't even have the individual right until 2008 when the Supreme Court interpreted it that way. So I always want people to think about what is freedom and what is this right, and is it an absolute right? Like I tell people all the time, like, you have a right to travel in this country. It doesn't mean that it can't be regulated. You have to have a registered motor vehicle. You have to have a driver's license. There are speed limits. There are insurance requirements. So there are limitations and regulations. So Congress can regulate a lot through the Commerce Clause, which obviously they could do with firearm sales as well. So I'm hoping that what this does is sort of like provoke some research and some thinking into it to say, what is a right? What is a freedom? What is an absolute right? Are these limitations and regulations? Can that be done? Can we do that? And the answer is yes. We can obviously limit and regulate. You know, they say the Constitution is a living, breathing document. And so that's why you'll see throughout history, we have very different interpretations, because as society progresses and how different things become available, obviously, we have to move along with the times and interpret it, or try to interpret it in that context. So I hope you get a chance to read it. If you can, the Heller. You can also look at, there was a case, I think 2 years later, McDonald versus Chicago, which also dealt with limitations on the Second Amendment right, and hunting and things like that. So, you know, one of the biggest limitations I always see, or that I come across, especially in Mississippi, are people with a felony conviction that lost the right to own and possess a firearm. So we have in this state, just a little legal tip, we have what they call a certificate of rehabilitation. And so that's because not all felony convictions are expungible, which means they can't come off of your record. But what we do have is called a certificate of rehabilitation. And what you do is you file that in the court in which you were convicted. So whatever court that was, and then it is completely discretionary to the judge. What you're asking for is the court to authorize a certificate of rehabilitation that authorizes you again to own a firearm, own and possess a firearm. And so I see that a lot with people that, you know, 10, 15 years ago, 20 years ago, they were being a silly young adult and got some like possession charge or whatever that carried this horrific felony, and it's not one that could be expunged. And so, you know, if you know anybody in that situation, you know, have them contact an attorney and say, you know, hey, what about a certificate of rehabilitation? Because I know I've had like at least 3 grandfathers call me before that wanted to take their grandson hunting, and they had gotten a felony conviction, you know, 30, 40 years ago that's not expungible, which just seems ludicrous to me. And so that is an avenue that's been able to help some people out in that respect. So I hope you like this video. I hope it gets you to thinking. And if you have any questions or comments, I'd be happy to answer them, or I look forward to reading them, and I am sure we will talk very soon. Thanks, bye-bye.